Your lawyer hasn't called you in 2 weeks. Your court date got pushed back again. You're starting to wonder if anyone is actually working on your case. Here's the truth. If your attorney is doing their job right, you're only seeing about 10% of the work. The other 90% happens behind the scenes, and that 90% is what determines whether you go home or you go to prison. I'm Richard Suzuki. I was an Assistant U.S. Attorney and Deputy Maricopa County Attorney before I became a defense attorney. I know what good defense attorney work looks like from both sides, and I know what keeps the prosecution up at night. Today, I'm pulling back the curtain so you know exactly what you're paying for. The work starts the moment you hire an attorney, not at the first court date. In fact, one of the most important things a defense attorney does happens before anything is filed in court. It's the initial case assessment, reading every piece of available documentation, the police report, the arrest report, any statements, any preliminary discovery, listening to the client's account of what happened, then sitting down and building a strategic picture. What is the government's theory? What evidence do they have? What evidence might they have that hasn't been disclosed yet? Where are the weaknesses in their case? What's the best realistic outcome, and what are the paths to get there? This assessment shapes every single decision that comes after. A good defense attorney doesn't just react to the prosecution. They build a counter narrative from day one. This is a piece most clients don't realize happens. A defense attorney should be conducting their own investigation, independent of law enforcement. That means going to the scene, photographing it, looking at angles the police report doesn't mention, finding witnesses the prosecution didn't interview or didn't want to interview, locating surveillance footage before it gets deleted, reviewing social media, consulting with expert witnesses, forensic experts, medical experts, accident reconstruction specialists, DNA analysis, and mediation specialists depending on the case type. Here at Suzuki Law, we have 2 retired law enforcement investigators working for you. As a former prosecutor, I know something critical. Police investigators build a case toward a conclusion they already have reached. They look at evidence that confirms their theory. A good defense attorney looks for what they missed or what they ignored. Sometimes that independent investigation turns up nothing new, but sometimes it turns up everything. Discovery is a formal process by which the prosecution shares its evidence with the defense. In Arizona, criminal cases, the prosecution is required to turn over all evidence that's material to the case, including exculpatory evidence, meaning evidence that could help you. This constitutional requirement comes from a Supreme Court case called Brady v. Maryland, and violation of it is serious. But here's the reality. Discovery doesn't always come in complete or organized fashion. It comes in waves: police reports, lab reports, surveillance footage, phone records, witness statements, and expert reports. A skilled defense attorney reviews all of it carefully, not just to understand what the prosecution has, but to look for what's missing, what's inconsistent, and what opens the door to challenges. I've reviewed discovery in cases where a key lab report was buried in hundreds of pages. I found discrepancies in police reports that told a completely different story than the narrative the prosecution was building. Discovery is not paperwork, it's intelligence. Motions are legal arguments filed with the court asking a judge to make a ruling. A motions phase of a criminal case can be as important as trial, sometimes more so. A motion to suppress is one of the most powerful tools a criminal defense attorney has. If evidence was obtained through an unlawful search, an improperly conducted traffic stop, a Miranda violation, or any other constitutional breach, a motion to suppress can get that evidence thrown out. Sometimes losing key evidence means the prosecution has no case. Sometimes it just weakens their position significantly for plea negotiations. Other critical motions: motions to dismiss when charges are legally deficient, motions to compel when the prosecution hasn't turned over required discovery, motions in limine that limit what the prosecution can say or show during trial, and motions challenging the admissibility of expert witnesses or scientific evidence. Clients rarely see this work happening, but when a motion is granted, the case changes overnight. The reality of the criminal justice system is the vast majority of cases, somewhere around 97%, received through plea agreements rather than trial. That doesn't mean defendants are rolling over. A well-negotiated plea can be the difference between a felony and a misdemeanor, between 5 years and probation, between a record that follows you forever and one that could be expunged. Skilled plea negotiation requires knowing the case inside and out. It requires knowing what the prosecution values: a quick resolution, avoiding the resources of trial, the likelihood of a conviction, and using that knowledge as leverage. It requires understanding the sentencing guidelines and how specific facts affect outcomes. And it requires being generally willing to go to trial, because prosecutors know when they're negotiating with someone who's bluffing. The attorney who goes into plea negotiation having done thorough investigation and filed aggressive motions is negotiating from a position of strength. The attorney who hasn't done that work is negotiating from weakness, and their client pays the price. When cases go to trial, the preparation is extensive. Jury selection, called voir dire, is itself a skill. Understanding which jurors are likely to be sympathetic, which are likely to follow a prosecution's narrative, and how to ask the right questions to surface that information takes experience and preparation. The opening statement sets the theme for the entire trial. Every witness examination, both cross-examining the prosecution's witnesses and directly examining defense witnesses, has to be prepared meticulously. The goal of cross-examination is not to bully or confuse, it's to surface inconsistencies, expose bias, hindsight what a witness doesn't know, and chip away at the prosecution's narrative. The closing argument ties it all together. A skilled defense attorney doesn't just argue the facts. They tell a story that gives the jury a coherent reason to find reasonable doubt. Zealous advocacy is a phrase used in legal ethics, and it means that defense attorneys have a professional obligation to fight as legally and ethically as possible for their clients. Not just show up, not just follow the motions everyone files, but to bring genuine strategic thought, thorough preparation, and real commitment to the outcome. This is the thing I tell anyone hiring a criminal defense attorney to look for. Not the biggest name, not the slickest website. Look for someone who asks the right questions, someone who knows the judges and prosecutors in the jurisdiction, because local experience matters enormously. Someone who actually explains your options and the strategy behind them rather than just telling you what you want to hear. Ask them, what's the theory of the defense? What motions do you think we should file? What investigation needs to be done? How do you handle plea negotiations? What does your trial experience look like? A good defense attorney answers those questions clearly and confidently. An attorney who can't or won't is a red flag. Communication. Are they returning your calls? Are they explaining what's happening and why? A client who doesn't understand what's going on in their own case is a client whose attorney is failing them. Preparation. When you go to court, does your attorney seem familiar with the specifics of your case, or does it feel like they're reading the file for the first time? Strategy. Is there a clear plan? Do decisions feel deliberate or random? Honesty. A good attorney tells you the hard truth. If the evidence is strong, they tell you. If a plea deal is the best option, they tell you. You don't need an attorney who tells you what you want to hear. You need one who tells you what you need to hear and fights like hell anyway. Everything we've talked about so far, arrest, Miranda, traffic stops, what your attorney does, that's mostly in the state system. But there's a whole other world that operates a different level entirely, with different rules, different stakes, and a process most people have never heard of. In the next video, I'm pulling back the curtain on the federal grand jury. What is it? What a target letter means? Why being a target is radically different from being charged, and why the indictment rate is nearly 100%. If you're ever wondered how federal charges actually begin, that's in my next video.